Good morning. Are you Cody Dent?
Yes, ma'am.
And Mr. Dent is on probation in two cases, 13-17772 and 22-41052 for the offenses of obstruction or retaliation and theft of property. Those both have motion to revoke pending. And then there is a new allegation or new indictment in cause number 250807 of burglary of a building. And Mr. Samuel,
Yes, Your Honor, I've been hired to represent Mr. Dent. I went out and visited with him this past weekend, and I've also spoken with him this morning. And as a result of my evaluation and talking with him, I believe it's merited to have someone appointed to give a professional evaluation. We realize that he is on probation. I realize there is a new charge. This is our first setting. I've not had an opportunity to complete discovery, but I think upon getting the information from discovery, and if we can set for bond hearing at a later date, maybe next week if possible, we believe that the results of that evaluation will show that there's possibly some alternatives that are available.
so it's set for bond hearing today on those motions, but you want some time to get up to speed on that other case. You want me to put that off, just hold it?
Yes.
Okay.
Yes.
All right.
At least until next week. I'd like a quick turnaround because right now there is no bond.
Right.
And he needs to get assistance.
Okay. An evaluation won't happen in a week.
I understand.
Okay, so but you still think give you a week to get up to speed,
Correct.
bond hearing next week,
Correct.
and then I'll look at your motion for the evaluation. We'll take care of that.
And
Right.
I'll talk with the prosecutor.
Okay. We'll reset it. How's next week? Are we?
Yes.
We're good? Okay. We'll reset it for 1 week for a bond hearing on those two motions.
Right.
Thank you.
Thank you, Your Honor.
Good morning. Are you Justin Franklin?
Yes, ma'am.
And in cause number 250514, Mr. Franklin's charged with aggravated robbery. Mr. Lewis, what is the announcement?
Well, Judge, I'm Mr. Franklin, I understand that the complainant witness had been in touch with the state on this one.
Judge, may I put a few things on the record, please?
Yes, ma'am, of course.
First, may I have the name Kayla Davis called?
Would you call the name Kayla Davis, please? Good morning, ma'am. Are you Kayla Davis? Ms. Malfino, do you need some time maybe to visit with her, or do you want to go ahead and put something
Go
on the
ahead,
record?
Judge, if you
Okay.
just mind swearing your...
Ms. Davis, would you please raise your right hand? Do you swear or affirm the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, ma'am. Thank you. Go ahead.
Ms. Davis, would you please state your full name for the record?
It's Kayla Davis.
Held you all at gunpoint and stole your purse and wallet, right?
He didn't hold us in gunpoint and he didn't steal my purse nor wallet.
Did you tell the police that that's what happened?
No, ma'am.
Okay. So if that's what the offense material reflects, and that's what the grand jury proceeded on with an indictment for aggravated robbery, are you saying under oath to the court today that that did not happen?
Yes.
And you have many times called my office asking that the case be dropped, correct?
Right.
You've come in and signed a non-prosecution affidavit.
Yes, I have.
You have called saying that this did not happen and that you're not going to cooperate with the state, correct?
Yes, I have.
Are you in fear of Mr. Franklin?
I'm not.
Is he pressuring you to do this?
No.
And do you understand that if the state does not proceed with this case, that you're taking matters into your own hands?
Yes, I do.
With respect to your safety?
Yes, I do.
And that's what you want me to do?
Yes, drop the case, please.
And you're asking Judge
I'm
West
asking
to
Judge
allow me
West
to drop the case?
To drop the case.
All right. All right, you can step back.
Thank you. And Judge, just for the record, if I may, obviously with those facts, obviously the court is aware of experiences you and I have both had in the past. I think there was something more to the incident. She's obviously not going to cooperate with me. She's obviously also his spouse. And so at this time, with the court's permission, I would move to dismiss, but I just wanted to be sure all of that was on the record so that if something were to happen in the future, everybody is aware that those were specifically her wishes.
All right, if that comes through based on all of that, I don't know how you can do anything else, and so I'll sign that. Mr. Franklin, I'm not sure what, if anything, happened. My thought is something did happen. Hang on, just let me talk, okay? Don't talk yourself out of this, because here's what can happen. It's not easy, but it is possible to go forward with cases without the complaining witness. So whatever happened needs to not happen again. You need to get a grip on whatever anger, whatever issues you have. If you've got someone here that cares about you and you want to be a part of their life, that's not what you do to people that you love.
Yes, ma'am.
And it's definitely not what you do where there are children involved.
Yes, ma'am.
Do you understand?
Yes, ma'am.
All right, go back with the bailiff. Good morning. Are you Tracy Haynes? And this is cause number 240514. I'm going to take judicial notice of the court's file. Mr. Haynes was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I received a packet from them dated June 23rd of 2025 with that report from Dr. Samantha Guzman with the opinion that Mr. Haynes has achieved competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No.
Then at this time, I will find Mr. Haynes is competent to stand trial. And will he waive the formal reading of the indictment, Mr. Parker? All right, Mr. Haynes, in cause number 240514, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of obstruction or retaliation from February 3rd of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
The stuff on the computer.
The stuff on that computer tablet, did you go over that before you signed it with Mr. Parker?
Yes.
And do you understand those documents that you signed? Speak up, please.
Yes, ma'am.
And do you understand if I follow the agreement that
Right out of the gate, Cody Dents in Deep 2 probation cases a new burglary charge and motions to revoke hanging over him. This isn't just a bond, hearing it's a high-stakes balancing act between second chances and legal consequences. Will the court bite, or is this his last shot?
you've made with the district attorney that you'll be waiving or giving up any right to appeal? So if I follow your agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone. Speak up, please. When you're answering, I need you to speak up. And sentence you in accordance with your agreement to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Good morning, sir. Are you Jack Hooper?
Yes, Your Honor.
And in cause number 17-27896, Mr. Hooper is on probation for driving while intoxicated, third or more. There was a motion to revoke filed. We were previously here. Entered pleas of true to counts 1 through 6. I've received an updated pre-sentence report, and the agreement was for a cap of 4 years. Is that correct?
That's correct, Judge. He's indicated to the probation officer, indicated to me that he would rather not be put back on probation. He's asking to be sentenced to 3 years. He doesn't have, he doesn't have any new cases as violations or the possession, testing positive. He seemed to report to the probation department and did everything he did. The problem was he had an issue with marijuana. we're asking that, I think he should be given some consideration to that. We're asking for a 3-year sentence.
So you stopped reporting back May 5th of 2021. So didn't really report as
I apologize.
Directed.
I spoke that.
you've been an absconder since 2021. Ms. Malfino?
Judge, I think the consideration that he was given was with the cap of 4 years. I completely understand if based on the original PSI and his history and his attitude, the court does not think that that is an appropriate amount. But I would obviously recommend revocation, whatever amount you think is appropriate. If we need to revisit that issue, we will.
What happened with the Sabine County DWI back in 2017 at the same time as this one?
They dropped it.
Okay, at this time, I'm going to find that you entered your pleas of true to counts 1 through 6. Find those counts true. Ms. Malfino is exactly right. You're lucky that you made a plea agreement for 4 years, because I'm not really sure that not showing up since 2021 and just saying I want to take my time and be done with it is the kind of attitude that I appreciate. But I'm going to find sufficient evidence at this time to revoke your probation, and at this time revoke your probation, reassess your punishment to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you the trial court certification that shows this was an agreement that I followed, and so you have waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Good morning. Are you Jeremiah Johnson?
Yes, ma'am.
And Mr. Johnson was previously here in cause number 250330, entered a plea of guilty to aggravated robbery, and 250331 also pled guilty to aggravated robbery. Cause number 250408 and 0409 pled guilty to theft of a firearm. The agreement on these were for a 10-year deferred on those 2 aggravated robberies and a 2-year term probated for 5 years on the theft of firearm cases. I've received the pre-sentence report. Has everyone had an opportunity to review these reports? Or the report? Are there any additions or corrections? Not real sure I want to go along with this plea agreement. Mr. Johnson?
Yes, ma'am. I promise that I'll do right this time.
This time?
Yes, ma'am.
You have been in trouble for breaking into people's cars, stealing guns, shooting at people over and over and over again.
Yes, ma'am. God showed me that this is not nothing I want to do in life.
When did he show you that?
Being in jail, incarcerated.
You've been in jail before. You didn't find God when you were there before?
Yes, ma'am. I'm not making no excuses.
Here's the thing. I hope you have.
Yes, ma'am.
I hope that you have found him. The problem is you lose them when you get out of jail.
Yes, ma'am.
And that's what a lot of people do, is when you're looking at time and you're incarcerated, you're like, oh, I don't want to do this. And then you get out and you go start doing the same thing because you think you're cool and you're going to go steal guns and you're going to shoot at people when they... You're lucky you're not here for murder.
Yes, ma'am. I got to be here for my little girl. I can't mess up no more. I can't afford to.
You're how old?
28.
You're 28.
Yes, ma'am.
You're way older than old enough to know better.
Yes, ma'am.
You know, this is something I see a lot of times with these.
The tension in the courtroom is palpable. Every delay, every request for more time could tip the scales. Cody's fate literally hangs in the balance. 1 week could change everything, or it could be too late.
15, 16, 17, 18-year-old kids. Your child's 7 years old,
Yes, ma'am.
so it's not like you have a baby and all of a sudden you know you need to be there for her.
Yes, ma'am. I know. I made a few mistakes in my life, but I'm willing to try to
That's an understatement, don't you think?
Yes, ma'am, I understand.
I appreciate too that you're being honest with me today.
Ma'am.
But I have to look out for the community as much as, you know, I kind of have two things I've got to do here. Figure out what's best for you, but also what's best for our community.
Yes, ma'am.
Your Honor, I will say when I first met with him that, I mean, early on, he's just said, I'm tired of this life, you know, I don't know why I'm doing this, and I need to get my stuff together. And do you have people, I understand exactly what the court says, everybody finds God and, I mean, Jesus in jail, you know, but sometimes I think there's some truth that when you're sitting there and it opens your eyes that, you know, you do realize that I'm getting too old for this. I'm just ready to settle down and do what's right. And he seemed to have that attitude when I first talked to him.
Yes, ma'am. I mean, I just ask if you give me one chance, just one chance to prove myself.
So I want to make sure, and we're going to go over that. If you get this chance and you violate it,
Yes, ma'am.
you got the rest of your life that I can give you in prison.
Yes, ma'am.
And when I have to spend some time and it bothers me, a lot of times I don't remember. People say, oh yeah, you remember when you put me on probation? I don't. I'll probably remember you.
Yes, ma'am.
Especially because you put things on your face so people can remember you by them. Probably not the smartest thing either, right? Okay. Any reason not to go forward with sentencing, Mr. Smith? All right, so here's what I'm going to do, Mr. Johnson, because of my concerns.
Yes, ma'am.
I'm going to give you an opportunity, but I'm going to hopefully give you some tools to be successful.
Yes, ma'am.
I'm going to find in each of your cases that you enter your pleas of guilty freely and voluntarily.
Yes, ma'am.
And find sufficient evidence to find you guilty. In cause number 250330, defer all proceedings, place you on probation for a period of 10 years.
Yes, ma'am.
You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'm going to go through certain conditions in a few minutes. In cause number 250331, find sufficient evidence to find you guilty. However, I'm going to follow the agreement, defer all proceedings, place you on probation for 10 years. You will pay a $500 fine in that case as well and follow all of the rules and conditions of probation. In cause number 250408, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that, you'll be on probation for 5 years in that case. You're also ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Cause number 250409, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. And you're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. One of the conditions of your probation in each of your cases is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program, so you're not getting out today. But I'm doing this to continue you hopefully making the better decisions. This program is all about making better decisions. Staying away from the people that you need to stay away from. If you really want to change your life, you can. People do it. It's not easy sometimes, but you're going to be given the tools. And if you don't, then you're back here, okay? And so here's something that's very important though. You have a handful of write-ups in our jail.
Yes, ma'am.
I see those. I'm going to see if you have any more between now and when you go to ISF. It will be a violation of your probation if you have more incident reports in our jail or if you have any in ISF.
Okay.
So if you are disrespectful to those officers that are just out there doing their job, if you're fighting, if you don't button your jumper up because you're too cool to button your jumper up, just follow the rules. When you're out and you're not in custody, you can make whatever decisions you want. When you are in custody, you're going to follow those rules. If you don't, again, that's part of your probation now, is that you follow all of those rules and don't get in trouble. You could be back in here on a motion to revoke your probation before you ever hit the streets again.
Yes, ma'am.
So whatever's going on in the jail, you better go in and say, whoever else is messing around, get on your bunk, do what you're supposed to, get to ISF, get out, do what you say you're going to do, okay?
You said how long ISF?
It's a 90-day program, okay? So you've got two separate things going here. Now, you've got the deferred probation on those aggravated robberies, which means at this time you don't have a conviction on those cases. That's a great thing for you. It also leaves it open, though, if you violate any condition of your probation, you're back in here, I can convict you of those offenses, and you could be sentenced to anywhere in the range of punishment, which is between 5 years and up to the rest of your life in prison, the whole range of punishment. Also, if you violate on those theft of a firearm cases, you've already agreed in those to the maximum punishment, which is 2 years in the state jail prison. So if you violate, you've already agreed to those 2 years. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Not just any charges, more felony charges. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, you can, or how long that lasts, you can talk to Mr. Parker. All right? Good luck. Take advantage of this opportunity. And Ms. Burge, if you'll please raise your right hand, do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, ma'am.
Thank you. Good morning. Are you Gerson Mendoza? And this is cause number 250304. Will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Mendoza, you're charged with the first-degree felony offense of aggravated robbery from December 1st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Judge West doesn't pull punches here. She's laying down the truth about accountability consequences and the real-world stakes, especially when children are involved. This isn't just legal advice, it's life lessons with a gavel.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis, with the interpreter? And do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, that you're waiving any right to appeal? And it looks like the agreement that you reached is for a 10-year deferred probation, a $1,000 fine, and you would be required to follow all of the rules of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yeah, ¿entiendes? Yes, ma'am.
And state tenders number 1,
No objection, Judge.
it's admitted. Is there any evidence that Mr. Mendoza is not competent?
No, Judge.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing so we can get a pre-sentence report done that'll give me more information about you and your case, and then we'll come back later for sentencing. What is the state's position with regard to a bond? based on the nature of the,
History is young age, he's 18 years old, which was several classmates that that was less,
I can't hear you.
I think he was less than the other defendant. There's a co-defendant in this case.
I'm not going to change the bond based on his age and the nature of the offense. A lot of times what I do in these is possibly ISF or something anyway, just because it had to do with a robbery and a weapon, and he's young. So let's just see what the pre-sentence report says. All right, so you can go back with the bailiff.
Now we hit a turning point. Mr. Haynes has pled guilty, competency confirmed, and the formal indictment reading is waived, a strategic courtroom move. But what does this mean for sentencing? Every choice here sets a legal domino effect in motion. The emotional weight hits hard. Witness testimony denials and conflicting accounts leave the truth murky. Is this devotion, fear, or deception? How the court navigates this could change the outcome entirely. Judge West switches gears. This is tough love with a roadmap for redemption, cognitive programs, probation conditions, real tools to rebuild a life. But make no mistake, fail to follow the rules, and it's back to court. The stakes couldn't be higher.
However, I'm going to reset this case for a sentencing hearing so a full pre-sentence investigation report can be completed. That report will give the court a clearer picture of you, your background, and the circumstances surrounding this case. Once that's done, we'll return at a later date for sentencing. Now state, what is your position regarding bond? Based on the nature of the offense and the defendant's history, the court is not persuaded to reduce bond. Yes, the defendant is only 18 years old. But age alone does not outweigh the seriousness of what's been alleged here. This case involves a robbery, a weapon, and public safety concerns, and that changes everything. For now, the bond will remain exactly as it is. The court will wait to see what the pre-sentence report reveals before making any final decisions about sentencing options moving forward. All right, you may return with the bailiff. And just like that, we've reached a turning point. The defendant has entered a guilty plea, competency has been confirmed, and the formal reading of the indictment has been waived. A strategic courtroom move with major consequences. Because now the real question isn't guilt, it's punishment. Every decision from this moment forward sets off a legal domino effect, and what happens next could shape the defendant's future permanently. But the emotional weight in this room is impossible to ignore. Testimony, denials, and conflicting details have left the truth tangled, and the court is now forced to separate excuses from accountability. Was this loyalty, fear, or calculated deception? Then Judge West shifts gears, firm, direct, and unapologetically clear. This isn't sympathy. It's tough love with a final roadmap toward redemption. Structured programs, strict probation conditions, and real tools designed to rebuild a life. But make no mistake, if those rules are broken, the court will have no hesitation. It's right back to this courtroom, and the consequences won't be lenient.